230 years ago today, the state of Virginia voted to ratify Articles 3 through 12 of the Bill of Rights, which comprise the first 10 amendments to the United States Constitution. The Old Dominion joined 10 other states to enact 10 measures proposed by Virginia Representative and future President James Madison, and over the next 10 days, I intend to offer an overview of each of them individually. Article 2 of Madison's proposed amendments was eventually ratified in 1992 as the 27th Amendment. So today I want to discuss the 2 of Madison's 12 articles that were never ratified nor incorporated into another amendment that was ratified. The first of those articles reads in full, "After the first enumeration required by the first article of the Constitution, there shall be one representative for every 30,000, until the number shall amount to 100, after which the proportions shall be so regulated by Congress that there shall be not less than 100 representatives, nor less than one representative for every 40,000 persons, until the number of representatives shall amount to 200, after which the proportions shall be so regulated by Congress that there shall not be less than 200 representatives, no more than one representative for every 50,000 persons." This article was ratified by 11 states, the most recent being Kentucky in June of 1792, and is known today as the Congressional Apportionment Amendment. According to one interpretation of the formula, which suggests that the number of citizens represented was meant to increase by 10,000 for every 100 representatives, the Congress of the United States today would include 2,346 members of the House of Representatives. 230 years ago today, the state of Virginia voted to ratify Articles 3 through 12 of the Bill of Rights, which consisted of 10 of James Madison's 12 proposed articles of amendment to the United States Constitution. 2 of Madison's 12 articles were never ratified nor incorporated into another amendment that was ratified. The second of those was designed to explicitly affirm the separation of powers described in Montesquieu's 1748 treatise, The Spirit of the Laws, and reads in full, "The powers delegated by the Constitution to the government of the United States shall be exercised as therein appropriated, so that the legislative shall never exercise the powers vested in the executive or judicial, nor the executive the powers vested in the legislative or judicial, nor the judicial the powers vested in the legislative or executive. The powers of the 3 branches of government are delegated in the first sections of each of the first 3 articles of the Constitution. Article 1 vests all legislative powers in a Congress of the United States, which shall consist of a Senate and House of Representatives. Article 2 vests the executive power in a President of the United States. And Article 3 vests the judicial power of the United States in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. Clause 2 of Section 1 of Article 2 of the Constitution also establishes that the President will be selected by a number of electors equal to the whole number of senators and representatives to which the states may be entitled, a body that was later referred to in Section 4 of Title 3 of the United States Code as the College of Electors. 230 years and 1 day ago, Congress ratified the Bill of Rights, which consisted of 10 of James Madison's 12 proposed articles of amendment to the United States Constitution, the third of which outlined 5 fundamental freedoms and reads in full, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances." The amendment was originally proposed as 2 separate articles, the first of which read, "Congress shall make no law establishing religion or prohibiting the free exercise thereof, nor shall the rights of conscience be infringed." This provision explicitly safeguards both the freedom from religion in its Establishment Clause and the freedom of religion in its Free Exercise Clause. In 1802, then President Thomas Jefferson wrote that the language of this amendment has the legal effect of building a wall of separation between church and state, and reiterated Madison's description of the amendment ensuring the rights of conscience. Following the Supreme Court ruling in Lemon v. Kurtzman 1971, the 3-pronged Lemon test was established to determine if a statute violates the Establishment Clause of the First Amendment. That test indicates that a statute must have a secular legislative purpose, must have a principal or primary effect that neither advances nor inhibits religion, and must not result in an excessive government entanglement with religion. 230 years and 1 day ago, Congress ratified the Bill of Rights, which consisted of 10 of James Madison's 12 proposed articles of amendment to the United States Constitution. The third article was originally proposed as 2 separate provisions, the second of which read in full, the freedom of speech and of the press, and the right of the people peaceably to assemble and consult for their common good, and to apply to the government for a redress of grievances, shall not be infringed. The final phrasing dictated in part that Congress shall make no law abridging the freedom of speech. The freedom of speech ensured by this provision specifically prohibits the government from interfering with, censoring, or retaliating against the free expression of the citizens, but does not protect criminal acts such as defamation, which includes false statements made with malicious intent, either verbally in the form of slander or in writing in the form of libel. In 1943, the Supreme Court further ruled in West Virginia State Board of Education v. Barnett that it is unconstitutional for public schools to compel students to salute the flag or recite the Pledge of Allegiance, or to punish them for refusing to do so, because saluting constitutes a form of utterance, and compelled speech is a violation of the freedom of speech. Associate Justices Hugo Black and William Douglas wrote, "Words uttered under coercion are proof of loyalty to nothing but self-interest." And Justice Robert Jackson added that to believe that patriotism will not flourish if patriotic ceremonies are voluntary and spontaneous instead of a compulsory routine is to make an unflattering estimate of the appeal of our institutions to free minds. 230 years and 1 day ago, Congress ratified the Bill of Rights, which consisted of 10 of James Madison's 12 proposed articles of amendment to the United States Constitution. The third article was originally proposed as two separate provisions, the second of which read, in part, "The freedom of the press shall not be infringed." The final phrasing dictated in part that Congress shall make no law abridging the freedom of the press. While a commendable sentiment, the freedom of the press has been regularly curtailed throughout American history under the pretense of national security, particularly by the Espionage Act of 1917, which criminalized statements intended to cause insubordination, disloyalty, mutiny, or refusal of duty in the United States military, and made them punishable by a fine of up to $10,000 and or up to 20 years in prison. While the Senate debated the provisions of the act, President Woodrow Wilson openly insisted that authority to exercise censorship over the press is absolutely necessary to the public safety. The Espionage Act was further extended by the Sedition Act of 1918, which criminalized any disloyal, profane, scurrilous, or abusive language used against the United States government, the American flag, or the United States military, and made that punishable by up to 20 years in prison as well. The Sedition Act was eventually repealed in December of 1920, but the Espionage Act still remains in effect today, and was used to charge Daniel Ellsberg and Anthony Rousseau Jr. with a felony after they published the report of the Office of the Secretary of Defense Vietnam Task Force, also known as the Pentagon Papers, in the New York Times in 1971. But the Supreme Court ruled in New York Times Company v. United States that Ellsberg and Rousseau were in fact protected under the First Amendment. 230 years and 1 day ago, Congress ratified the Bill of Rights, which consisted of 10 of James Madison's 12 proposed articles of amendment to the United States Constitution. The third article was originally proposed as two separate provisions, the second of which read, in part, "The right of the people peaceably to assemble and consult for their common good shall not be infringed." The final phrasing dictated in part that Congress shall make no law abridging the right of the people peaceably to assemble. The right is referred to as the freedom of association in NAACP v. Alabama 1958, which ruled that the state of Alabama had violated both the due process provision of the 14th Amendment and the right to assemble provision of the First Amendment when the state issued a subpoena demanding the membership lists of the National Association for the Advancement of Colored People, because, as Associate Justice John Marshall Harlan II said, compelled disclosure of affiliation with groups engaged in advocacy may constitute as effective a restraint on freedom of association as the forms of governmental action in the cases above were thought likely to produce upon the particular constitutional rights there involved. Harlan further asserted that the inviolability of privacy in group association may in many circumstances be indispensable to preservation of freedom of association, particularly where a group espouses dissident beliefs, and compared Alabama's demand that the organization disclose the identity of its members to a requirement that adherents of particular religious faiths or political parties wear identifying armbands. The freedom of assembly is one of the three legs, along with the freedom of speech and the freedom to petition, upon which stands the right to protest, which is itself not separately listed as a right or freedom in the text of the Bill of Rights. 230 years and 1 day ago, Congress ratified the Bill of Rights, which consisted of 10 of James Madison's 12 proposed articles of amendment to the United States Constitution. The third article was originally proposed as two separate provisions, the second of which read in part, "The right of the people to apply to the government for a redress of grievances shall not be infringed." The final phrasing dictated in part that Congress shall make no law abridging the right of the people to petition the government for a redress of grievances. This provision echoes the language of the Declaration of Independence, which asserted in part that in every stage of these oppressions we have petitioned for redress in the most humble terms. Our repeated petitions have been answered only by repeated injury. The right to petition was borrowed from the English Bill of Rights 1689, which provides for redress of all grievances and for the amending, strengthening, and preserving of the laws, and can be traced as far back as the Magna Carta Libertatum. Ironically, the United States Supreme Court ruled in Minnesota Board for Community Colleges v. Knight, 1984, that nothing in the First Amendment or in this court's case law interpreting it suggests that the rights to speak, associate, and petition require government policymakers to listen or respond to communications of members of the public on public issues, which seems very much like an excellent way to recreate the exact situation that led to the American Revolution in the first place. The right to petition is one of the three legs, along with the freedom of speech and the freedom of association, upon which stands the right to protest, which is itself not separately listed as a right or freedom in the text of the Bill of Rights. 230 years and 2 days ago, Congress ratified the Bill of Rights, which consisted of 10 of James Madison's 12 proposed articles of amendment to the United States Constitution. The fourth article originally read in full, "A well-regulated militia composed of the body of the people, being the best security of a free state, the right of the people to keep and bear arms shall not be infringed, but no one religiously scrupulous of bearing arms shall be compelled to render military service in person," but was eventually modified to read simply, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." The right to own and operate firearms previously appeared in the English Bill of Rights 1689, where Sir William Blackstone described it as a supplementary right that exists in support of the rights of self-defense, bodily autonomy, and resistance to oppression. In 1788, Madison claimed in Federalist No. 45 that the federal government may accumulate a military force for the projects of ambition, but argued that the state governments, with the people on their side, would be able to repel the danger of such a standing army. He further argued that a standing military ought not exceed 1/100th part of the whole number of souls of a nation, and in fact the military today consists of just 1 in 238 Americans. For the first 217 years of its existence, the right to keep and bear arms was held to be a collective right, intended, as Blackstone argued, as a civic duty to act in defense of the state, and not until the Supreme Court affirmed in District of Columbia v. Heller 2008 was the Second Amendment considered to describe an individual right. 230 years and 3 days ago, Congress ratified the Bill of Rights, which consisted of 10 of James Madison's 12 proposed articles of amendment to the United States Constitution. The fifth article was approved by the House of Representatives on August 24th of 1789, by the Senate on September 9th of 1789, and by the Congress at large on September 25th of 1789 without modification, and reads in full, "No soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war but in a manner to be prescribed by law." Here the term quartering refers to the act of providing living quarters, and this measure was enacted in response to the British Quartering Acts of 1765 and 1774, which required American colonies to pay for British troops serving in the colonies, and if military barracks provided insufficient lodging, to house soldiers in any accommodations available, including private homes. Quartering large bodies of armed troops among the colonizers was specified among the grievances listed in the Declaration of Independence. This is the amendment that those who fly the blackened American flag are mischaracterizing. Black flags have historically been associated with both piracy and anarchism, as well as the Black Standard of Islam, which was flown by the Persian general Abu Muslim during the Abbasid Revolution in the 8th century. The context in which certain Americans fly their own black standard today is as an announcement that they intend to give no quarter to American citizens that they've identified as enemies, meaning that no prisoners will be taken and no survivors will be left, which is a war crime under Rule 46 of the Geneva Conventions, as well as Section 2 of Article 8 of the Rome Statute of the International Criminal Court. 230 years and 4 days ago, Congress ratified the Bill of Rights, which consisted of 10 of James Madison's 12 proposed articles of amendment to the United States Constitution. The sixth article was approved by the House of Representatives on August 24th of 1789, by the Senate on September 9th of 1789, and by the Congress at large on September 25th of 1789 without modification, and reads in full, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." One severe curtailment of these provisions resulted from Terry v. Ohio, 1968, in which the Supreme Court ruled that police may stop and question pedestrians on the street even without probable cause to arrest, so long as the officer has a reasonable suspicion that the person has committed, is committing, or is about to commit a crime, and that police may perform a surface search of the person's outer clothing for weapons if they have reasonable suspicion that the person stopped is armed and presently dangerous, though that suspicion must be based on specific and articulable facts. This resulted in what has become known as a Terry frisk, and when extended to the temporary detainment of persons in vehicles, to Terry stops, which laid the groundwork for pretextual stops, in which police are authorized to stop vehicles for minor infractions in order to investigate a person on other suspicions. Associate Justice William O. Douglas voiced a sharply dissenting opinion in the case, arguing that "We hold today that the police have greater authority to make a seizure and conduct a search than a judge has to authorize such action. We have said precisely the opposite over and over again. To give the police greater power than a magistrate is to take a long step down the totalitarian path. Perhaps such a step is desirable to cope with modern forms of lawlessness, but if it is taken, it should be the deliberate choice of the people through a constitutional amendment." 230 years and 5 days ago, Congress ratified the Bill of Rights, which consisted of 10 of James Madison's 12 proposed articles of amendment to the United States Constitution. The 7th article was originally proposed as 2 separate provisions, which were merged to read in full, "No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation." The amendment introduces the double jeopardy clause, which prohibits defendants from being prosecuted again for the same crime in several circumstances, and also ensures the right to refuse to answer questions that might expose oneself to an accusation or charge of a crime, otherwise known as pleading the fifth. The Supreme Court ruled in Miranda v. Arizona, 1966, that statements made by an individual can be used at trial only if they are made after the individual has been informed of their Fifth Amendment right against self-incrimination, the individual has understood that right, and the individual has waived that right. The disclosure of this right has since become known as a Miranda warning, the administration of which is known as Mirandizing. The court also ruled in Berghaus v. Tompkins, 2010, that merely remaining silent does not constitute an invocation of Fifth Amendment rights, but that the right to silence must be explicitly and unambiguously invoked. The amendment also introduces the first appearance of the Due Process Clause, which later appears in the 14th Amendment, and which is further elaborated in the provisions of the 6th Amendment. 230 years and 6 days ago, Congress ratified the Bill of Rights, which consisted of 10 of James Madison's 12 proposed articles of amendment to the United States Constitution. Originally proposed in more truncated language, the 8th article now reads in full, "In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial, by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense." The right to a speedy trial was elaborated by the Supreme Court's 1972 ruling in Barker v. Wingo, which listed 4 considerations: the length and reason for a delay, the time and manner in which a defendant invokes the right, and the degree of prejudice caused to the defendant by a delay. The Supreme Court also ruled in Shepard v. Maxwell, 1966, that the right to a public trial can be suspended if excessive publicity would damage a defendant's right to due process. The court ruled in Williams v. Florida, 1970, that a jury as small as 6 members is sufficient to provide an unbiased trial, and ruled specifically in Ballou v. Georgia, 1978, that as few as 5 jurors is unconstitutional. The right to the assistance of counsel recognizes the right of defendants to represent themselves before the court, but Powell v. Alabama 1932 ruled that in a capital case where the defendant is unable to employ counsel and is incapable adequately of making his own defense because of ignorance, feeble-mindedness, illiteracy, or the like, it is the duty of the court, whether requested or not, to assign counsel for him. 230 years and 7 days ago, Congress ratified the Bill of Rights, which consisted of 10 of James Madison's 12 proposed articles of amendment to the United States Constitution. The 9th article was originally proposed as 2 separate provisions, which were combined into one that reads, in full, in suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. The amendment has been described as being virtually a self-explanatory provision, and its guarantee of a trial by jury was specified in Colgrove v. Batten 1973 as requiring a jury of at least 6 members for civil cases, in line with the court's ruling in Williams v. Florida 3 years prior that a jury as small as 6 members is sufficient to provide an unbiased trial in criminal cases, while as few as 5 jurors is unconstitutional according to a decision in Ballou v. Georgia 1978. While most individual states also guarantee jury trials in civil cases, the Supreme Court has ruled consistently that the 7th Amendment does not require them to do so, unless the case in question is decided under federal law. The $20 provision of the amendment is rarely invoked. Section 1332 of Title 28 of the United States Code, which refers to diversity of citizenship, provides that the matter in controversy exceeds the sum or value of $75,000 in order for the case to be heard in federal court if it is between citizens of different states or citizens of a state and citizens or subjects of a foreign state. Adjusted for inflation, $20 in 1791 is equivalent to about $590 today. 230 years and 8 days ago, Congress ratified the Bill of Rights, which consisted of 10 of James Madison's 12 proposed articles of amendment to the United States Constitution. The 10th article is borrowed nearly verbatim from the English Bill of Rights 1689 and reads in full, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. In 1878, the Supreme Court ruled in Wilkerson v. Utah that cruel and unusual punishments include drawing and quartering, disembowelment, burning alive, and public dissection, but ruled that death by firing squad was constitutional. The court added in Robinson v. California 1962 that breaking on the wheel, burning at the stake, crucifixion, the rack, thumbscrews, and in some circumstances even solitary confinement were also cruel and unusual. In Trop v. Dulles 1958, the court ruled that revocation of citizenship violates the 8th Amendment because denationalization as a form of punishment destroys for the individual the political existence that was centuries in development. In Furman v. Georgia 1972, Associate Justice William J. Brennan Jr. laid out 4 principles by which we may determine whether a particular punishment is cruel and unusual, which include that a punishment must not by its severity be degrading to human dignity, inflicted in wholly arbitrary fashion, clearly and totally rejected throughout society, or patently unnecessary. 2 of the 5 justices in that case found capital punishment in and of itself to be unconstitutionally cruel and unusual, while the ruling also affirmed that the 8th Amendment was designed to be regularly reinterpreted in accordance with the evolving standards of decency that mark the progress of a maturing society. The Roberts Court rejected the argument that capital punishment is cruel and unusual in Bucklew v. Precythe 2019, citing that the 5th Amendment added to the Constitution at the same time as the 8th expressly contemplates that a defendant may be tried for a capital crime and deprived of life as a penalty so long as proper procedures are followed. The court ruled that people with mental handicaps may not be executed in Atkins v. Virginia 2002, and that people under the age of 18 at the time of the crime may not be executed in Roper v. Simmons 2005. 230 years and 9 days ago, Congress ratified the Bill of Rights, which consisted of 10 of James Madison's 12 proposed articles of amendment to the United States Constitution. The 11th article was intended to address the concerns of Federalists who argued against the addition of the Bill of Rights, and reads in full, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." The amendment expresses that while various rights such as the freedoms of speech or the press, or freedom from unreasonable search and seizure, or the right to a speedy and public trial may be explicitly articulated, the rights of the people are not limited only to those explicitly articulated in the Constitution and its subsequent amendments. The right of bodily autonomy, for instance, is not specifically enumerated in the Constitution, but it nevertheless remains unquestionably a right retained by the people because it provides the foundation for the right of self-defense, which in turn provides the foundation for the right to keep and bear arms. This was the rationale under which the Supreme Court ruled in Roe v. Wade 1973 that the Ninth Amendment encompasses the right to choose to have an abortion, despite the fact that right is not otherwise explicitly articulated in the Constitution, because the amendment's reservation of rights to the people is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. Similarly, the right to protest is not specifically enumerated, but it nevertheless remains a right retained by the people that is guaranteed by the combination of the rights of speech, redress, and peaceable assembly. The amendment explains that the rights protected by the various provisions of the text are by no means exhaustive, and reaffirms the function of the Constitution specifically as a document by which the people assign the rights that they allow the government to exercise. 230 years and 10 days ago, Congress ratified the Bill of Rights, which consisted of 10 of James Madison's 12 proposed articles of amendment to the United States Constitution. The 12th article complements the 9th Amendment's stipulation that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people, and reads in full, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people." The amendment echoes the sentiment expressed in Article 2 of the Articles of Confederation, under which the United States had operated for the preceding 8 years, which read, "Each state retains its sovereignty, freedom, and independence, and every power, jurisdiction, and right which is not by this Confederation expressly delegated to the United States in Congress assembled." The provisions of the 10th Amendment sometimes encounter friction with the Supremacy Clause that appears in Article 6 of the United States Constitution, and states, "This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding." In ratifying the Constitution, the states of the Union agreed to the stipulation that federal law supersedes state law should a conflict arise between the two. And the Supreme Court ruled in Marbury v. Madison 1803 that in declaring what shall be the supreme law of the land, the Constitution itself is first mentioned, thereby establishing that the Constitution is itself law and not merely a manifesto, as well as ruling that the particular phraseology of the Constitution of the United States confirms and strengthens the principle supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void.